Welcome to Benussi Law TV. Today we're going to talk about collaborative law, which is a subject lots of people have heard about but aren't quite sure what it is. My partner, Helen Jane Arnold, is here to talk about collaborative law. She's trained in the subject, she's got a lot of experience in the subject, and I think it's fair to say that after the first few years of collaborative law in process, she's got some pretty good views on how it works out. So, Helen Jane, what is collaborative law?
Collaborative law is an alternate process to the court-driven process. It's an opportunity for a couple to sit down around the table and to work out what issues they want to discuss together, and with the help of their lawyers to be able to talk through those issues. It often involves a sequence of meetings, perhaps up to 4 or 5, and there's an agreement in the meantime that there is to be no correspondence passing between solicitors, and it's regulated by an agreement, which means that the lawyers are not able then to go to court. So it's a voluntary process which will let a couple talk through the issues between themselves.
How do you know a case is suitable for collaborative law?
It's very important to talk to a client at the very outset to make sure that it is a suitable case. It's very important that there's a large degree of trust between them. The discussions are going to involve open information, often about financial issues. And there has to be a willingness to talk frankly and openly, and a willingness to want to reach an agreement.
Why would someone choose to do a case collaboratively?
Because it enables a couple to be able to, at the end of their relationship very often, reach a dignified solution to their problems. It lets them sit around the table with their lawyers, talking about how they want to sort out those important issues for them.
Is it cheaper?
No, it's not a cheaper process, but it's one that means that the couple are in control of the process. It's possible to discuss with lawyers beforehand as to the cost of each meeting, and it is possible to control the cost, but it certainly can't be looked on as a cheap option, but it's certainly the best. And if it reaches an enduring agreement, then it's a means of getting the family issues sorted out, and it will be cheaper than the court-driven process, that's for sure.
And how does the collaborative case finish?
It finishes when the people involved have reached an agreement on all of the aspects that they want to resolve between themselves. The agreements that have been reached are set out in a written document, and that document can be put into the court, and the judge can be invited to make an order which finalises their issues, the financial issues between them once and for all. It is possible to reach agreement in relation to children issues as well, and generally once an agreement is reached there's no need for an order, but it's also possible to put in that written agreement and invite the judge to make an order as well.
Okay, thank you very much indeed. There we have it. You've had a description of collaborative law and how it works. We have a picture now of couples sitting round with their lawyers, working through an agenda and coming to an agreement that they've both worked on and they're happy with. It's a process that can be easier for people. But sometimes we have wives come in to tell us that they want to go through the collaborative process, and then they go on to describe their partner, and we know that the process isn't going to work because he's a controlling man who's in charge of everything, and she's a wife who's not used to putting her point of view. So there has to be the right mix for collaborative law to work properly. And if that mix is there, it will, and we, with Helen Jane's help, will see that process through for you.